Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today's video is a reaction to yesterday's press release regarding Lucy Letby, in which her barrister, Mark McDonald, announced his intention to apply to the Court of Appeal to reopen its determination of Ms. Letby's application for leave to appeal. We will explore the legal basis for such an application and share our perspective on whether it holds any merit. So stay with us until the end to reach your own conclusion. The application will argue that Dr. Dewi Evans is an unreliable expert witness and that the Court of Appeal may have been misled in assessing his reliability, and consequently all the convictions are unsafe. Let's unpack all of that. As we know, one of the grounds relied by Ms. Letby in her application for permission to appeal was that the trial judge was wrong in refusing the defense's application to exclude the evidence of Dr. Evans. Specifically, McDonald asserts that the court was not informed of significant shifts in Dr. Evans' opinions, which could have affected the court's determination on his reliability. Going into the details, he said that since Lucy Letby's trial concluded, Dr. Evans has appeared in several documentaries and podcasts in which he revealed that he no longer stands by reports provided for at least 3 of the babies, baby C, baby I, and baby P, and that he has provided the police with a new report in the case of baby C. McDonald said that despite numerous requests for disclosure, he is yet to receive this report. He added that in his 26 years career as a barrister, he has never known of an expert to change his mind on the cause of death a year after the convictions. He said that to him that was astonishing. Let's break down the application that Mark McDonald plans to submit to the Court of Appeal. First, let's answer 2 questions. Is a Court of Appeal decision final? And can a case ever be reopened after a decision? The answer to both is essentially yes. A Court of Appeal decision is final, but there are rare circumstances where the court can reopen a case. This ability to reconsider a decision comes from the court's inherent powers, often called implicit jurisdiction. These powers allow the court to strike a balance between 2 key objectives: a private objective, correcting errors to ensure fairness and justice for the parties involved, and a public objective, maintaining public confidence in the justice system. The court also has a residual jurisdiction to prevent significant injustice. However, because there is a strong public interest in the finality of legal decisions, this power is used only in exceptional cases, as reopening a case could in itself cause injustice. Let's look at how these principles were elaborated and established. These principles were first elaborated in the case of Taylor and Lawrence in 2002. This was a civil case that clarified that the Court of Appeal has indeed authority to reopen decisions where serious errors or injustices had occurred. These principles were later embodied in the civil procedure rules under Part 52. Later in 2015, in the case of Regina versus Yassin, the Court of Appeal Criminal Division confirmed that the same principles from Taylor and Lawrence applied to criminal cases. However, while the interest of justice is at the core, criminal cases involve more complexities. Unlike civil cases where there are 2 parties, criminal cases also consider the interests of victims and the public. This, the court says, makes the principle of finality more critical in criminal cases. Furthermore, they say in criminal cases there is already an alternative remedy, the Criminal Cases Review Commission, or CCRC. The CCRC exists to review potential miscarriages of justice and can refer cases back to the Court of Appeal, providing a safeguard without undermining the finality of decisions. McDonald, however, had already anticipated these issues, noting that an application to the CCRC requires fresh evidence and is an extremely lengthy process that could take years. Indeed, he mentioned a case in which he is involved, which has been with the CCRC for 8 years. We assume he's referring to the case of Colin Norris. Despite the case having been referred to the Court of Appeal in 2021, the matter has not yet been decided. So how does this application work in practice, and what should McDonald prove? The procedure can be found in Rule 3615 of the Criminal Procedure Rules. First, the application must be in writing and must be made as soon as practicable after becoming aware of the grounds for doing so. The application must specify the decision which the applicant wants the court to reopen, which we know is the decision of the Court of Appeal for leave to appeal, and explain why it is necessary for the court to reopen that decision in order to avoid real injustice, how the circumstances are exceptional and make it appropriate to reopen the decision, notwithstanding the rights and interests of other participants and the importance of finality, why there is no alternative effective remedy among any potentially available, and any delay in making the application. If we examine the Court of Appeal's reasoning for rejecting the first ground of Lucy Letby's application for leave to appeal, which argued that the trial judge was wrong in admitting Dr. Evans' evidence, the court emphasized that the timing of the challenge was significant. The court noted that the application to exclude Dr. Evans' evidence was made by the defense partway through the trial rather than pre-trial. This, the court argued, suggests that the issue was not with Dr. Evans' qualifications or competence, which should have been raised earlier, but instead with how he delivered the evidence during the trial. The court noted that assessing the quality of a witness's statement is fundamentally a task for the jury. However, this raises a critical question. How can a jury accurately judge the reliability of a witness if that witness changes their opinion or demonstrates uncertainty after the trial has concluded? A witness who shifts their position post-trial raises clear concerns about their reliability and the confidence placed in his evidence. If such a change of opinion had occurred during the trial, it might have caused the jury to doubt the witness's credibility altogether. Given this, in our view, the Court of Appeal should recognize such developments as exceptional circumstances, as defined under Rule 3615. The post-trial change in Dr. Evans' stance could arguably meet the threshold for reopening the case, as it directly impacts the safety of the convictions and undermines the reliability of key evidence. I hope you found this insightful, and if so, let us know in the comments below. Also, don't forget to like this video and subscribe to our channel if you have not done so already, to help us in our mission to humanize the criminal justice system. Join us again as we sit and rise in this unique trial.